Welcome to SCOTUS Cast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-argument episode of SCOTUS Cast, Armed Career Criminal Act and Violent Predicate Felonies Edition. I'm your host, Bridget Flaherty. On October 9, 2018, the Supreme Court heard arguments in Stokeling v. United States and the consolidated cases United States v. Stitt and United States v. Sims, all disputes that involve the Federal Armed Career Criminal Act, ACCA. ACCA imposes a 15-year mandatory minimum prison sentence on any federal firearms offender who has 3 or more convictions for a violent felony or serious drug offense. In determining whether any given predicate felony conviction qualifies as violent, federal courts apply a categorical approach that looks only to the elements of the predicate offense and not the underlying facts. If the elements include, quote, the use, attempted use, or threatened use of physical force against the person or property of another, the conviction qualifies as a violent felony. In Stokeling v. United States, the U.S. Court of Appeals for the 11th Circuit held that Stokeling's Florida conviction for robbery by sudden snatching categorically qualified as a violent felony. The Supreme Court granted certiorari to consider whether that analysis holds when the state offense includes as an element the common law requirement of overcoming victim resistance, and state appellate courts have required only slight force to satisfy that element. In United States v. Stitt, consolidated with United States v. Sims, both defendants persuaded federal courts of appeals, the Sixth Circuit for Stitt and the Eighth Circuit for Sims, that their sentences were improperly enhanced because predicate burglary convictions under the laws of Tennessee and Arkansas, respectively, involved elements categorically broader than the generic burglary encompassed by ACCA. ACCA deems burglary a violent felony, but takes a generic view of burglary that may be narrower than some state burglary laws. The Supreme Court consolidated the 2 cases and granted certiorari to consider whether burglary of a non-permanent or mobile structure that is adapted or used for overnight accommodation can qualify as burglary for purposes of ACCA. And now, to discuss the case, we have Luke Millian, professor of law at the University of Louisville Brandeis School of Law.
This podcast offers a post-argument summary of 3 cases involving Congress's Armed Career Criminal Act, otherwise known as ACCA. The cases are United States v. Stitt, United States v. Sims, and Stokeling v. United States. Due to the similarity of the questions presented, the Stitt and Sims cases were consolidated for briefing and oral argument, and Stokeling, though briefed separately, was argued on the same day as the others. ACCA was enacted by Congress in 1984. It was amended in relevant part in 1986. The statute prescribes a 15-year minimum sentence for defendants convicted of a firearms offense who have 3 or more prior convictions for a violent felony. The statute defines violent felony as follows: any crime punishable by imprisonment for a term exceeding 1 year that has as an element the use of physical force against another person, or is burglary, arson, extortion, or involves the use of explosives. 2 parts of ACCA's definition of violent felony are at issue in these 3 cases. The Stokeling case involves the meaning of the term physical force. The Stitt and Sims cases deal with the term burglary. To assess whether a previous conviction constitutes a violent felony under ACCA, courts employ a categorical approach. Rather than reviewing the record of the underlying conviction to determine whether the defendant actually engaged in violence, the pertinent question is categorical, whether the crime of conviction was a violent felony. In answering this question, courts assess statutory text and judicial interpretations of such text. The categorical approach was adopted by the Supreme Court in its 1990 decision, Taylor v. United States. It's notable that despite the flaws of the categorical approach as identified by several justices, None of the parties in these three cases are asking the court to upend the categorical approach. Denard Stokeling pleaded guilty in federal court in 2016 to being a felon in possession of a firearm. His sentence was enhanced under ACCA based in part on his 1997 conviction of robbery in Florida. Applying the categorical approach, the 11th Circuit framed Florida's robbery statute as a violent felony, based on its conclusion that it has as an element the use of physical force against another person. The Supreme Court granted Stokeling's cert petition. The court will not be writing on a blank slate here. In Curtis Johnson v. United States, decided in 2010, the court examined the meaning of physical force in the ACCA statute. Writing for a 7-2 majority, Justice Scalia observed that physical force in the ACCA statute means violent force. That is, force capable of causing physical pain or injury. At another point in the opinion, Justice Scalia explained it was force strong enough to constitute power. So the question in Stokeling comes down to this. Does Florida's robbery statute require physical force as used in ACCA? If so, it's a predicate crime under ACCA. If not, it falls outside ACCA. Stokeling gets at this question from both ends. He sees the force requirement of the Florida statute as broad. It requires merely the slightest resistance to overcome the slightest force. He in turn frames the ACCA standard of physical force to be that which is reasonably expected to cause pain. Because the robbery statute in Florida criminalizes behavior lacking ACCA physical force, it is not, according to Stokeling, a violent felony under ACCA. Not surprisingly, the United States argues the other way on both points, for a broader construction of ACCA physical force and a narrower construction of the Florida statute. Citing to Curtis Johnson, the United States suggests ACCA physical force is that level of force which is capable of causing pain. It in turn argues Florida's robbery statute, which has been held to require force sufficient to overcome resistance, mandates as a practical matter a physical struggle over a piece of property. Because any physical struggle over a piece of property will meet the ACCA standard of capable of causing pain, the Florida robbery statute is, according to the United States, an ACCA predicate crime. In addition, the United States points to the purpose of ACCA to enhance gun crime sentences for violent felons. If the Florida robbery statute were deemed to be outside of ACCA, then ACCA will be largely gutted. The robbery statutes of upwards of 40 states will be excluded, and only half of the states will have any robbery statute qualifying as an ACCA predicate. Stokeling counters that this concern is overstated. Based on his review of state robbery law, a ruling for him would leave the robbery statutes of only 6 states outside of ACCA. Let's now turn to Stitt and Sims. To qualify as a violent felony under ACCA, a crime need not include physical force. Even without physical force, a crime is a violent felony under ACCA if it is a burglary, arson, extortion, or involves the use of explosives. In Stitt and Sims, the court is asked to consider the meaning of burglary in the ACCA statute. Victor Stitt had his firearms conviction enhanced under ACCA based on a previous conviction in Tennessee for aggravated burglary. Aggravated burglary in Tennessee applies to any habitation defined by the Tennessee Code to include modules, mobile homes, trailers, and tents, as well as occupied vehicles that are designed or adapted for the overnight accommodation of persons. In an unrelated prosecution, Jason Sims had his firearms conviction enhanced under ACCA based on an Arkansas conviction for residential burglary. Residential burglary in Arkansas criminalizes the unlawful entrance of a vehicle in which any person lives or that is customarily used for overnight accommodation. Stitt and Sims appealed, and their cases eventually made their way to the Supreme Court. Their cases were consolidated for briefing and argument. The basic question before the court in Stitt and Sims is whether the burglary statutes in Tennessee and Arkansas covering certain kinds of vehicles constitute burglary as understood in the ACCA statute. If so, they are predicate crimes under ACCA. If not, they fall outside of ACCA. The United States begins by reciting the Supreme Court's test from Taylor. To understand the scope of burglary in the ACCA statute, one must examine, quote, the generic sense in which the term burglary is now used in the criminal codes of most states, unquote. In 1986, when ACCA was most recently amended, the burglary statutes of all states applied to paradigmatic dwellings like buildings. But most states had burglary crimes that went so far in terms of location to cover at least some kinds of vehicles, those which are adapted or used for overnight accommodation. According to the United States, 43 states and the District of Columbia had burglary statutes like this in 1986. As a result, the United States' position is that generic burglary under ACCA should be understood to cover vehicles adapted or used for overnight accommodation. On this point, the United States and respondents play what Justice Gorsuch calls the numbers game. Applying a categorical approach in Taylor, the court limited ACCA burglary predicate crimes to those burglary statutes criminalizing no more than generic burglary. Working within Taylor, the United States argues that if the locational line of generic burglary were drawn to exclude vehicles adapted or used for overnight accommodation, then only 12 states would have burglary statutes narrow enough to serve as ACCA predicate crimes. But if the terms of generic burglary were drawn to include vehicles adapted or used for overnight accommodation, then 31 states would have burglary statutes that could serve as an ACCA predicate offense. The United States emphasizes that 31 does more work than 12, and it would be odd for Congress to have enumerated burglary as a violent felony under ACCA, while at the same time limiting its reach to the burglary crimes of only 12 states. Respondents first addressed this point by correcting the government's math. The respondents believe that only around half the states would have burglary statutes that fall within ACCA, even under the government's definition of generic burglary. So the actual comparison is not 12 versus 31, but something more like 12 versus 25 or 12 versus 26. In addition, the respondents challenged the government's premise that Congress wanted ACCA to be expansive. They suggest that casual sentencing enhancement was not Congress's goal. After all, the enhancement under ACCA is severe, 15 years, and so it would make sense that Congress would have been selective about which crimes served as predicates. Beyond the numbers game, the United States raises several other points to support its claim that generic burglary should include vehicles adapted or used for overnight accommodation. It cites to the Model Penal Code, which since 1980 has defined occupied structure in regards to burglary to include any structure, vehicle, or place adapted for overnight accommodation. It also draws the court's attention to the U.S. Sentencing Guidelines, which in 1986 applied burglary of a dwelling to vehicles. Stitt and Sims respond that the United States definition of generic burglary under ACCA is unduly broad. They seize on language in the Taylor opinion suggesting generic burglary is limited to the invasion of a building or other structure. From there, they draw the court's attention to a conventional distinction in the law between structures and vehicles. Structures under the law include only those mobile entities whose primary purpose is overnight accommodation. This definition excludes mobile entities simply adapted or used for overnight accommodation. So on one side are floating homes and mobile homes, legal structures according to the respondents, and on the other are RVs, sleeping vans, and boats with sleeping quarters, which do not have as a primary purpose overnight accommodation, and as a result are merely vehicles under the law. To support this distinction, respondents cite to Fourth Amendment case law, HUD regulations, and local zoning ordinances. The respondent's point is that generic burglary covers structures, not vehicles, and as a result excludes mobile entities merely adapted or used for overnight accommodation. This narrower understanding of generic burglary leaves Tennessee and Arkansas's burglary statutes outside of ACCA. As a fallback argument, respondents claim that the state burglary statutes at issue are not captured by even the United States' proposed definition of generic burglary. For instance, the Arkansas burglary statute applies to vehicles in which any person lives, and in terms of location, this extends to vehicles not adapted or used for overnight accommodation. Some of the justices expressed concern that this argument was not properly raised in the responses to the cert petitions. Justice Gorsuch called it a nifty little argument, but said it was raised late in the day. As a result, he wondered aloud whether it would be best to just remand the case. In conclusion, it's notable that during oral arguments, several justices indicated frustration with the state of ACCA litigation. Justice Gorsuch observed, "If you survey circuit judges across the country about one gripe they have with this court's jurisprudence, it may be ACCA." In reference to earlier decisions by the court, Justice Alito explained that you might have gotten a hint that a majority of the court really hates ACCA and is picking it apart bit by bit. Justice Breyer reflected, "Congress wrote 10 words in this statute. It thought it had a simple task. All we have to do is look to state law, and then we'll see whether it's a violent crime or not. But Congress forgot that there are thousands of state laws with variations all over the place. Do you know when the last time was that I thoroughly looked into state criminal law? It was my first year of law school, and I'm not sure how much I looked into it even then." On these points, Justices Breyer, Alito, and Gorsuch likely speak for many members of the federal judiciary. ACCA litigation, as it stands, seems to ask far too much of the federal courts. And so now we wonder, will a solution emerge in Stokeling, Stitt, and Sims? Or will the solution to the problems of ACCA litigation come from somewhere else? Perhaps their original source, Congress.
Thank you for listening to this episode of SCOTUS Cast. SCOTUS Cast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUS Cast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.